Excellencies, honorable ministers, ambassadors, distinguished speakers, colleagues and friends, I'm very happy to welcome everyone to Riga Graduate School of Law for a panel discussion on a topic that's very close to my own heart as well as to the Riga Graduate School of Law, namely upholding and protecting and promoting fundamental values of the European Union. Riga Graduate School of Law was established some 15 years ago exactly for that reason and for that purpose, to prepare Latvia and the fellow Baltic states for accession to the European Union, to meet the criteria and to join the European Union, to develop a culture of democracy, human rights, rule of law. This is something Latvia has accomplished with flying colors, one may say, and here at Riga Graduate School of Law we're very happy to begin to partner with the Latvian authorities in developing initiatives in the same vein aimed towards the eastern neighborhood of the EU. We teach fundamental values of the European Union, and we also bring in students from both other EU member states and neighboring countries to take part in core courses teaching rule of law, principles of open society, democracy and human rights. I very much join Andris Spruds in emphasizing the topicality of this question. It's topical from a local perspective, a local point of view with the current developments, also the developments in the Ukraine and elsewhere, but it's also topical in a broader sense, in a broader perspective. My own native country, Denmark, is a country where questions are being raised continually about issues having to do with international cooperation, human rights, democracy, where are the limits, what's the reasonable degrees of interference from outside in the decision-making process, and so on. And I think many other fellow Europeans know that these kind of questions are being raised all over the continent. I'm sure the director of the European Agency for Fundamental Rights has a lot to say about this as well. So we have a lot of challenges at home, so to say. We also have challenges in the international arena where we are trying to uphold and promote fundamental values in our external relations and where we're being met with challenges, met with questions, met with competing paradigms for development, competing paradigms for international relations. So I think it's a very timely and a very important initiative that has been taken. I'm happy that Denmark is one of the four sponsors, but I congratulate all four countries, Denmark, Finland, Germany, and the Netherlands, for taking this initiative. And I also congratulate the Fundamental Rights Agency for the work it's doing in this area towards a joint European framework for upholding fundamental rights. So once again, welcome. I look forward to rich presentations and challenging discussions amongst all of us. And thank you to the European Commission, thank you to Providus, and thank you also to the Latvian Institute for International Affairs for the partnership in organizing this event. And yes.
Thank you. So since I'm a moderator, I guess I can fulfill also those duties. So Ambassador Henk van den Dool, Ambassador of the Netherlands, the floor is yours since you are one of the major co-organizers of this event. Please.
Thank you very much. Good afternoon, everybody, Madam Minister, colleagues, excellencies, ladies and gentlemen. It is a great pleasure for me to welcome you to this afternoon's seminar about rule of law and fundamental values in the European Union. The European Union, ladies and gentlemen, is founded on the values of respect for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights, including the rights of people belonging to minorities. These values are common to the member states in a society in which pluralism, non-discrimination, tolerance, justice, solidarity, and equality between women and men prevail. Those of you who know their European law will have recognized my previous two sentences as a literal and complete quotation of Article 2 of the EU Treaty, to which all 28 member states have signed up. All the 28 member states of the European Union, therefore, may be expected to adopt a constructive attitude towards strengthening the rule of law in the interests of the rights of the European citizens and of continuing and enhancing existing cooperation within the European Union. Particularly since the EU is now increasingly confronted with questions about its public support base, it is important to boost confidence in decisions made by authorities in the member states which affect EU citizens in other member states. For example, in relation to the free movement of persons or the European arrest warrant. There must be no doubt about the foundations in the rule of law that are common to the member states or about their importance to European citizens. It's vital, therefore, to optimize the rule of law within the European Union. The Euro crisis, corruption indexes and human rights reports undeniably show deficiencies in this field. They need to be remedied with full respect for the legal systems in the member states. Not only should we make the workings of the rule of law in all member states more transparent and improve our understanding of them, we should also convince our citizens that we are indeed a community of common values, as described in Article 2 of the treaty which I just cited, with an independent judiciary, anti-corruption procedures and a reliable police force. We need to set the bar high, and we have to make sure that our own countries are an example of what we expect from candidate countries. The rule of law issue was raised some 7 years ago by the then Dutch government. The Minister of Justice in that government was very much at the cradle of this whole discussion. His name is Ernst Hirsch Ballin, and I'm very proud that he is here with us today to share his insights. I'm well aware that some people in some member states have had serious doubts about the motives that inspired the Dutch government to push this agenda. Let me reassure you, our constitution says that the Dutch government must promote the development of the international legal order. This is our only goal. By no means do we seek to undermine solidarity between North and South, or between old and new member states. We are not in favor of a system of naming and shaming. No, we simply believe that improving the rule of law throughout the European Union is essential if we are to win popular support for the EU. European citizens and companies should have access to a single area of justice. Every individual member state is in a sense part of every other member state. It is essential that Dutch tourists, Latvian investors, or British multinationals can implicitly trust all the legal systems within the European Union. Ladies and gentlemen, as Ambassador of the Netherlands, I am by definition speaking to you on behalf of the Dutch government. However, I'm very happy to point out to you that today I'm also speaking on behalf of the ambassadors of Germany, Denmark and Finland. In March 2013, the Ministers of Foreign Affairs of these 4 member states wrote a joint letter to the President of the European Commission, Mr. Barroso. In their letter, the ministers called upon the Commission to develop proposals to come up with a new and more effective mechanism to safeguard fundamental values in the member states. They pointed out that, and I quote, "At this critical stage in European history, it is crucially important that the fundamental values enshrined in the European treaties be vigorously protected. The EU must be extremely watchful whenever they are put at risk anywhere within its borders, and it must be able to react swiftly and effectively to ensure compliance with its most basic principles. We propose addressing this issue as a priority and believe that the Commission has a key role to play here." Unquote. Initially, the initiative of these 4 countries was met with, let's say, a lukewarm reception by the Commission as well as by some other member states. Partly because of the suspicions I mentioned earlier, partly out of fear for duplication with the work of other organizations, such as the Council of Europe, and partly on the basis of the false assumption that creating a new mechanism would entail opening up and renegotiating the treaty. It took representatives of the Netherlands, Germany, Denmark and Finland quite some time to convince everybody of the necessity and usefulness of our initiative and of the honesty of our intentions. But I'm happy to say that we came a long way. Not only is our initiative now joined by a considerable majority of the member states, it has also for a large part been embraced by President Barroso and Commissioner Reding. Last month, on the 11th of March, the European Commission presented a framework to safeguard the rule of law in the European Union. The communication of the Commission should be seen as the Commission's response to the letter of our 4 ministers. It's now up for discussion in the Council and in the European Parliament. It will not surprise you, therefore, that the timing of today's seminar, which will be followed by similar events in Vilnius tomorrow and in Tallinn probably in June, is not entirely coincidental. Let me conclude this introduction, ladies and gentlemen, by commending the Latvian Ministry of Foreign Affairs, the Latvian Ministry of Justice, and Minister Baiba Broka personally for their commitment, by thanking our esteemed panelists in advance for being willing to share their thoughts with us, by thanking the Riga Graduate School of Law for hosting us this afternoon, and last but not least, by thanking my fellow ambassadors and all the colleagues in the embassies of Germany, Denmark, Finland, and the Netherlands for all the work they put into the preparation of today's event. I wish you all an inspiring seminar. I thank you for your attention, and I'm happy to give the floor to Minister Broka. Please.
Your Excellencies, ladies and gentlemen, dear guests, first of all, it's a great honor to be one of the key speakers and welcome everybody in this very important conference. And I think it's very important also to mention the topical conditions we are having not only in the European Union but in the world in general today, and just trying to reflect the comment which was used by Mr. Spruds also, that there is a saying that Russia is from Mars and European Union from Venus. And interestingly, just yesterday at night I was reading a book about the man is from Mars and woman from Venus. And interestingly, it's about how different we are. Even sometimes we are speaking the same language, you know, but we do not understand each other, I mean man and woman. And it means that it's quite difficult to find a common denominator in order to see how to move forward. And if we allegorically try to reflect the same to the situation Russia and European Union. So it's very important. So if you look what is the justification of the activities, how the Russia is explaining why they're acting in a way, they have their own very interesting understanding about the rule of law, about the fundamental rights which they think they're protecting. At the same time, we have completely different understanding about the rule of law if we look from the perspective of the European Union. What is really crucial, and therefore it's very important because our people living in our countries, they require and they deserve explanation, and they deserve very active activities from the government showing what is our understanding about the rule of law in the European Union. And so it's not about only the principles we are declaring, but it's very much about that, what content we are putting in this very fundamental concept, rule of law. Through the ages, through the centuries, a lot of philosophers are trying to find a content, explaining through the ages what is the really topical perspectives, topical issues about the concept. Today, if we're looking forward, first of all, of course, I would like to express my gratitude to the ambassadors of the Netherlands, Germany, Finland, and Denmark about the great initiative to organize this conference, which I understood is only first initiative in Latvia, and then will be followed in Tallinn in Lithuania, and next week in Finland also there will be some kind of very similar conference when we will discuss those issues. And it seems that it just shows how important it is for European Union and right today. It's very important to mention that next week we will mark also this 10-year anniversary of the biggest expansion of the European Union since its creation, when also Latvia joined the European Union. And by joining, we we promise to our people, we promise to our colleagues, European Union member countries, that we will appreciate and we will follow the rules of law and fundamental values of European Union. This was not only a, geographical expansion, but, and the most importantly, a consolidation of nations that share common European values, the rule of law and the respect for human rights. And if we look back to those years, the European Union has flourished and its understanding and ability to safeguard these common European values. And we have developed an agenda of very bold reforms to strengthen and practical application of the fundamental rights towards its citizens. However, of course, it is a never-ending story. It never will end. It always will require the further activities. Whilst many of these fundamental rights reforms have already been successfully implemented, there still is a necessity to reassure that we do not lose our vigilance to protect the rule of law within the European Union itself. As a Minister of Justice, I truly believe that the respect for the human rights, democracy, and the rule of law is not only an abstract concept. It is a foundation of which the European Union is built upon. By continuously respecting and protecting these values, we are providing our citizens a strong confidence in the safety, freedom, and justice, and hence an overall prosperity. The rule of law is therefore a constitutional principle with a substantial importance in the context of our mutual relation. The area of justice, investment, trade in goods and services is largely dependent on the mutual relations we share with other European Union member states. Therefore, it comes as no surprise that growth economies are often very well equipped to protect the respect for rule of law, and as a consequence also for the fundamental values which the rule of law aims to protect. The rule of law principles are enshrined in large variety of unions acquis, starting from the Commission's impact assessments in the context of legislative proposals to judgments of the Court of Justice of the European Union and the European Court of Human Rights. European Union has already established a common understanding of the importance of the rule of law and the benefits it creates, from safeguarding European values and human rights to enabling an effective economy. Nevertheless, we still have a room of opportunity to work together within the European Union in order to achieve advancement in protection of those values. This would not only strengthen the European Union within, but also add to its credibility abroad. With this in mind, I would like to one more time welcome Danish, Finnish, German, and Dutch initiative to start a discussion on the best ways how to strengthen the existing legal framework in order to safeguard and sustain the rule of law and fundamental values in the European Union. Recently, we have also welcomed the European Commission's communication on the new framework in which the Commission has proposed three stages principle for the protection of fundamental values in the European Union member states. This will be a good source of inspiration too. The initiative is a good starting point for a constructive dialogue within the European Union to promote the culture of respect for the rule of law. The interaction of this initiative with the existing legal framework in the Council of Europe, the United Nations, and European Union itself has to be assessed carefully. We should not be looking towards an overlap of competencies from a substantive point of view and its added value. We should not create another administrative burden to the member states with another pre-review mechanism filling in the papers. Having in mind the underlying notion of solidarity and sincere cooperation, it is our duty as well as a particular strength to use a broad toolbox of instruments and policies that we already have and will have at our disposal due as a new rule of law initiative. And even though this should be a Commission-led process. We shall all jointly seek ways how to maintain and foster the confidence of the European partners and strengthen the direct link between the capacity of the European Union and the culture of respecting fundamental rights. After all, in the increasingly independent world of the 21st century, the respect for fundamental rights and freedoms within the member states must be recognized not only as a keystone for nations' development, but also as a prerequisite for the Union's prosperity. Thank you for the attention, and I'm wishing for everyone fruitful discussions and a lot of inspirations for further activity. Thank you.
Thank you, Minister. Thank you for the overview of Latvian position as well, and I think also the underlining the importance of the whole discussion in Latvia in general. And I just asked Minister if the Minister would be willing to reply to some questions. And the Minister is open.
Yes.
We have open government in Latvia, if you may
Very
notice. So, and that's why I would take a short round of short questions, if there are some. Please, immediately, so before we come to the panel. Nobody is willing, so in this case I would ask myself. So I was asking this question actually for sake of my, having the privilege also of asking. You mentioned actually I mentioned Russia from Mars, European Union from Venus. You added to this women from Venus and men from Mars. Would you say, to extend this analogy, would you say also that there are actually differences within the European Union of perceiving what are the fundamental values? And are some countries, like whatever the 4 countries what we just mentioned, are from the Venus, and probably some other countries are from the Mars, not always sharing all opinions and all the fundamental values interpretation of them?
Probably it's quite difficult to have a really diplomatic answer to the question you asked, but probably if we look to the 28 different national countries being members of the European Union, we should really consider that we are quite different in some kind of understanding because of our different history, about our different cultures, traditions. So definitely there should be, or there, not should be, but there is some particular, how to say, differences in understanding some of the basic values or targets we would like to reach. But what is very important, as I told, even if we are different, to agree on the content of the common denominator based on the fundamental rights, and not only to declaring what is the common denominator, what we agree upon, but also the way how we move toward in order to reach these targets. This is the most important because not only within the country, but in all kind of cooperation, we should agree, once we come together, there should be a compromises, there should be agreement on the behavior, on the targets, on the way we go forward. And this is very important to find and agree which is the value, which is the limit, which target we want to achieve. And after that, to put the road and to find the appropriate tools and techniques how to reach this. Because the framework we agreed upon, it's a European Union. All the countries joined absolutely freely, and I think for Latvia that was the best and the right decision to be a member of the European Union. We really appreciate to being there. And at the same time, it's very important also to agree between our countries what are the understanding and the content of the values we're talking about.
Excellent, Minister. Thank you. So actually, you underline, I think, one of the really fundamental values is compromise seeking and also consensus building within the European Union. And that's why actually the paradox is that since one of the fundamental values, it's not always easy to agree on all the fundamental values because we are, first of all, community about the compromise building and consensus building. But still, I could see some hands. Let's make it, as I said, not one by one, but the questions, 2-3 questions, and we come back to the Minister. So just one short round of those questions. Please, the mic is... Yeah, the mic is over there. And please introduce yourself.
My name is Ernst Broka, and I wanted, I mean, since this is the very discussion about where we want to go, I want to ask a controversial question on the compromise, and maybe to spark a bit of that air into the discussion that will follow. The compromise very often is the least common denominator. And I would like to see the values to uplift us to a much better Europe. This one is going down, and the compromise probably can make it go down as a stone. So, what do you think can be these things that can uplift us as Europeans together for something good?
Okay, thank you. And we take another question, please.
Hello, my name is Casper Zavicius, and I'm from the Association of LGBT and their friends Mosaic. And I would like to ask your personal opinion about the recent initiative about the referendum on banning the so-called homosexual propaganda initiated by Mr. Liebermans and
Okay, and the last one, please here, and please introduce yourself.
Hi, I'm Raghav, and I'm a PhD fellow at the RGSL. And my question is relating to the fundamental values and promoting it within the European Union, but how does it work when you especially take it outside the European Union? Because the world's, EU has to interact with other countries, so how do you do it? How do you, we all spoke about negotiation and common denominators, but how do you take it from here? And if she could answer that, that would be quite nice. Thank you.
Okay, so thank you, Minister. So please select the emphasis, what you would like to emphasize in this regard, because we still would move to the panel as well, and that's why we have experts to already go into
how many
details.
hours you plan for your conference? So then I have to otherwise, So of course, first of all, I will try to reply to Mrs. Voik, and I think I'm very positive. I think that Europe is not going down. I still think that every changes or every challenges we see in front of, I think it's always going forward to something good. And this is, how to say, it's my attitude. Even if we are coming together, yes, there are some conditions and some circumstances which put our together and look to some of the values more intensively right now. But I would say that the European Union in general is going absolutely right way, and also this conference shows that it's very important to come together and to talk about those values from today's perspective. But I don't think that it's going really down. So hopefully, at least from my perspective and the people I'm working together in the ministry, we look very positively how we can really also help and promote and to go to give to our people and to Latvia also something better, being a part of European Union. What relates to your question about the referendum, it's one of the values of the rule of law, fundamental rights. Every association, every organization has the freedom to initiate all kinds of activities. If there is some NGO which want to make some initiative referendum of the topical issue, if they think it's very important to get, feedback from the society, from my perspective, I cannot say that it's something illegal. They have all the rights to promote their point of view, to see how many people supporters do they have, and from the fundamental rights of the human rights, it's absolutely legal. They can do this. The same as, for all kinds of, there is a lot of initiatives about a lot of issues where the people are making some public referendums or interviews in order to get to know what is the status. The issue as such, this is, I'm not so sure, I'm not so fully involved what is really arguments, how they're trying to make, what is the topic about. But as you told, if they're trying to see how to promote maybe the traditional understanding of the family values, which is protected by the Constitution of Latvia, so it's a one issue. Or if they're trying to obey human rights in a way which is not appropriate in order to facilitate facilitate to the freedom of the people, to the freedom of the human rights, and a way to select the way and how to live, it's absolutely against. So if it is within the concepts of human rights and express freedom of their thoughts and views, I don't think that there is something illegal. But I'm not really, I haven't read any kind of this description about the referendums that they are going to organize. So, sorry. Sorry about that.
Okay, Minister, I think
that,
yes.
About the philosophy, as I told also, it was like a global concept about the, sorry.
Yeah, I mean, my question was, we are finding it hard to, share fundamental values within 28 countries, but how do you take it outside the 28, and how are you going to take it to the rest of the world? Because EU does play a major role in global politics, so that doesn't make sense.
But I think we'll also come back to this one, Minister, just shortly, because I think we'll come back to the panel and the EU representatives, so we can also discuss from that perspective. But please,
just one sentence. I think, first of all, once we have absolutely clear agreement between us, 28 countries, and we are strong on a base on fundamentals about the understanding the fundamental rights, I think it's logically we have very strong how to backbone to promote and express our values to all the other rest of the world. I think that's very important, and that's actually what the European Union is doing right now, when it's a very, geopolitically, it's a very sensitive period right now. And I think the attitude and the explanation European Union is also coming up, it's absolutely is ensuring that we have quite different understanding about the rule of law as our neighbor country.
Minister, with this, you already indicated implicitly, diplomatically, that there are some time limits and that we have to come already back to the panel. So I think thanks for answering the question. I think you proved that our government is open, intelligent, and also very representative. So thank you so much for coming and providing, let's say, your introductory remarks and also questions. Thank you once more.
Thank you, and I apologize, but I really have to leave and run for next meeting. Thank you, and fruitful discussion. Thank you.
Okay, and with this, I have the pleasure already to sit down and to come back to the panel. Thanks to the people and speakers in the first part who gave already quite a background to start the discussion, and we have representatives of the countries which have been also very supportive of the initiative. We also have the Latvian representative here. So just to have a short introductions of our distinguished panelists, we have Robert Harms, who is advisor of the Minister of Justice of Finland. We have Ernst Hirsch Ballin, the former Minister of Justice of the Netherlands, and also now a professor at the University of Amsterdam and University of Tilburg. Then we have Morten Kjærum, Director of the EU Agency for Fundamental Rights, so representative of the EU. With her previous capacity was director of the Danish Institute of Human Rights, or for Human Rights. So you had some background also in Danish experiences, Danish position. Even at the moment you are more the EU representative. We have Viktors Makarovs, Parliamentary Secretary of the Ministry of Foreign Affairs of Latvia. Viktors, it's good to have you also on the panel. And last but not least, we have Stefanie Schmahl, Professor for German and Foreign Public Law, at the Julius-Maximilians-University Würzburg, Germany. Also German representative from think tank and from the university. So very good also to have you on a panel. So let's start. Let's start with Mr. Robin Harms, who is advisor to the Minister of Justice of Finland. And my question, I guess, would be, and I would really request kindly to have maximum some 7 minutes of introductory remarks, but I would also at the same time shape your introductory remarks by my question. And my question would be, what is the value for the citizens to have all this discussion at the moment? Me as an average citizen, what the benefits would be for me at the moment, exactly now, to start the whole discussion, to participate in the discussion and to have some results? What is the citizens' perspective on this? Please, the floor is yours. It functions, but it was a kind request to speak quite closely to the mic.
Okay.
So at least to have it closer a little bit.
Thank you, Chairman. And thank you very much to the fellow organizers of this event, and especially to the Riga Graduate School of Law for organizing this event. It was lovely to arrive in beautiful and warm Riga this morning after having been skiing in Lapland yesterday. First of all, I think the chairman posed the question, do we have common values? And I'm very pleased that we do, both legally speaking, but also I think that most Europeans, speaking from the heart, think that we have common values. And they are, I think, a great platform to build upon. I've also tried to address your very specific questions, which is extremely relevant. Of course, the most relevant question is how can this benefit this discussion and promoting human rights and fundamental values? How can it really help on the individual level? I will make a few general remarks, and then I will also briefly come with some points on how my government, Finland, sees that the initiative on this new rule of law mechanism that helpfully will bring us forward, how we look upon how it could be built. First of all, the discussion on the building a new mechanism or a new method, I think it's at the very core of European integration. It is of great importance to my country, and we have been very active, as the Dutch ambassador also said, that there have been many countries that think that this is a really important question. We think that it's very important that that we look at this in the broad perspective. We're not only speaking in legal terms of rule of law principles, but we also actually address our common fundamental values, which is much broader, and we think that the mechanism that finally will be set up should also have the perspective of looking whether we together and as individual member states fulfill the fundamental values we have enshrined in the EU treaty. This discussion is very timely. It's a time of big challenges, I would say, but it's also a time of opportunities. We have European elections just around the corner. There will be a new parliament. There will be a new commission with a new working agenda, and new priorities will be set. And the question is, of course, is this going to be one of the priorities of the Commission and of the countries that have initiated it and the other countries. When it comes to the challenges, in my perspective, I think that the biggest challenge for fulfilling each and everyone's human rights in the EU at the moment is the growing nationalism and the disrespect for minority rights. I think this is a moment that we are finding ourselves in Europe today. We have growing nationalism, we have extremism, and concretely looking at different results from surveys made by the FRA, Fundamental Rights Agency, by national institutes, we have a lot of discrimination, and fundamental rights are not fulfilled in our member countries. My own country, Finland, is one of them. And I think this whole debate on our common values and how we should strengthen the rule of law, we should not dramatize it. We should avoid politicizing it. We should directly look at this as a question of whether we, on the individual level, can fulfill the rights and the common values we have. It's no problem for me here as a representative of my government to say that we have problems in Finland. We have great problems with discrimination of Roma. There was just recently a report published by the Ombudsman for Minorities, which indicated that almost 70% of the Roma population, they are about 10,000 in Finland, almost 70% of them feel that they have been discriminated during the last year. All of these are, of course, not concrete individual cases that you could go to court with, but it's discrimination is very much also about the perception of being discriminated. In several Eurobarometer surveys, we have found that especially the people with Somali background in Finland feel and are being discriminated. I have myself worked in the Ombudsman for minorities where we also deal with individual cases, and it's everyday life, unfortunately. And finally, the Fundamental Rights Agency just very recently came up with a report on violence against women in the EU. And I'm sad to say that the Nordic countries, including my own, we didn't score well. Actually, violence against women was found to be quite common in our countries. And I think it's very good that this kind of result, we get this kind of results from independent bodies, because only then our governments can address them. And it shouldn't be any problem for us on the common EU level to discuss them. And my government is very much of the opinion that discussions on upholding the rule of law and our fundamental values should be discussed on a yearly basis at the Council. If we do this regularly, without addressing a country's problem when it occurs, then we don't dramatize it as much. And then there we come to my concrete things. My government would like this new mechanism or method, or what you would call it, what we believe it should and hold. It should be a regular, yearly or bi-yearly review of how on the ground fundamental values and the rule of law principle is respected in each and every member state. We think that the Fundamental Rights Agency should have a crucial role here with its expertise, but also we should also use other available information from the Council of Europe, which is very much working on this issue, UN treaty bodies, etc. I think I've used my 7 minutes, so I will stop here, and then I'm happy to comment on later on.
Okay, thank you. But I will immediately have some short follow-up question on what you just said, because my question was about the citizens' gains from let's say this initiative and discussing the whole fundamental values discourse and putting it on the table, on political and legal table. And what does it mean? It means what's happening right now. It means that the individual human rights fundamental values have deteriorated. It's now a critical mass that we should discuss it, or it's pretty much the same. So what we see some decline of, let us say, observance of those compliance with fundamental values in recent years. Why it's exactly happening right now? Why this initiative has appeared? Is it some specific context for it?
Well, I think you can say that situation in many different member states. There has been a clear disregard of fulfilling the human rights of individuals, and in legal terms, of course, you can bring individual cases to the court of human rights.
Can I shortly just interrupt? Could you name those states as well, because we speak a little bit vaguely, and I understand there is some diplomatic element all of this, but still we should put on the table.
Chairman, I clearly see your point, but I think the whole idea with this is not naming and shaming. The idea is to have a regular mechanism so that we don't dramatize and don't pick out a single country. We have a review of all the 28 member states, quite in detail. And what I think the added value would be is that if we bring it to a very high political agenda where this is being discussed. This is what we would like to see. Very seldomly, human rights, respect for human rights and fundamental values are issues that are on the agenda of the Council. This we would like to see.
Okay, so even though I think in some reports we can see quite clearly what are those countries, and I think it's also not to sort of to keep the distance and to avoid the naming. We don't need to immediately shame them, but I think naming the problems, I think it's also important, and it happens in concrete contexts as well. But I think we'll come back to this. And with this, I'm happy to give floor to former Minister of Justice, Hirsch Ballin, who, as I understand, also was one of the founding fathers of this idea, contributed to this idea. And please, the floor is yours. And I would immediately perhaps continue the previous question. There are different nation states, and the Netherlands have been one of the driving forces behind the whole initiative. What are those nation states? Why there are differences among the nation states? Why the Netherlands have been so active in this regard?
Well, I think it's important to recognize from the outset that it's not an initiative about the others. It's an initiative about ourselves, us European citizens. And maybe that is the best and only answer I can give to your question. We didn't take this initiative because we want to blame other member states. We want to support the coherence of the European Union with respect to the rule of law. We have the funds, the cohesion funds, about the infrastructure throughout the European Union. We have the policies of harmonization with respect to economic activities, with respect to air pollution and so on. But the air that all of us have to breathe is the air of the rule of law, of serving democracy and human rights and rule of law. And that is, these three concepts can't be separated from each other. They are about the position of the citizens and their organizations and their initiatives in their societies. And then, as our societies are intertwined, so are the legal systems and the importance of the quality of the legal systems throughout the European Union. We have recently presented, as the Advisory Council on International Affairs, an advisory body to the Dutch government, a report about this issue. And the Dutch government is now preparing its position with respect to this advisory report. It will be dealt with together with the recent proposals from the European Commission about the same issue. These proposals are different from ours, but I don't think that they exclude each other. The European Commission's initiative is about activities of the European Commission in order to strengthen the rule of law in the European Union. And the process that we recommend in this advisory report, which is now available in English as well on the website of the Advisory Council on International Affairs, is much more about a bottom-up process, which has, in our view, to start with a sort of peer review between specialists from the member states of the European Union member states. And of course, this initiative has to rely upon existing expertise, which can be derived from, for instance, from the reports of the Fundamental Rights Agency of the European Union, from the case law of the European Court of Human Rights and the Court of Justice of the European Union, from reports of ombudsmen in the member states and the European Union ombudsman maybe as well, and from non-governmental organizations. So it's basically a bottom-up process. And we think that it might be important to develop a systematic approach with respect to all this information which is already available So in our view, we don't need new investigations throughout the European Union, but we have to work with the insights, the expertise that is already available about the rule of law quality of the member states. And then recommendations could be developed in a truly intergovernmental process between peers from the member states and submitted to the Council of Ministers of Justice and the Interior of the European Union. And they should deal with recommendations about how to improve the rule of law quality within the member states. And then their conclusions and recommendations should be communicated to the European Council in order to give it sufficient political leverage. That means that in our view it is important to have this process which starts with the knowledge that we have already and which could be made available in a process of strengthening the rule of law quality throughout the European Union. Why is it important? Why is it important, to go back to your first question to Mr. Harms, for the citizens of the European Union? As I said, it's not about the others. It's not a mechanism that has been designed in order to blame the others, whilst telling ourselves that we are perfect. None of us is perfect. We have cases in the European Court of Human Rights, in our own national courts and supervisory bodies, all of us, which indicate that there is room for improvement. Nevertheless, it is important for the European citizens to have a reliable quality of observance of the rule of law throughout the European Union. Why? For instance, because on the basis of the European arrest warrant, a citizen of any member state might have been see himself transferred to another member state and will face pre-trial detention. Maybe the pre-trial detention in other member states is unnecessarily long, is under conditions that we should not recognize as meeting the qualities, the standards of rule of law throughout the European Union. Or let's give another example. If somebody in commercial activities, in investments, goes to a different member states and wants to develop a project, a business in the other member states, but is confronted with lengthy procedures with respect to a permit for construction or for the establishment of his economic activity, then it's again the quality of the rule of law, the quality of the procedures that is really important with respect to the feeling of being European citizens throughout the European Union. We are aware, of course, of the fact that the idea of European Union, of European identity, has been challenged in many member states in recent years by new xenophobic or unduly nationalistic forces. But in this situation, we should work on the very basics of having a European Union, and that is the idea of European citizenship. As I said, rule of law, human rights, democracy are intertwined concepts. And the importance for all of us that we should recognize and strengthen is that we all are European citizens with equal rights.
Minister, thanks. And just to make it clear, I would have a follow-up question again. You mentioned, I think, a very important phrase, the keyword in many regards, the bottom-up approach. On the other hand, I understand that still a recent initiative started with a letter of 4 ministers of foreign affairs last year, 2013. Of course, the whole debate has been a longer one already, yeah. but pretty much that also the recent phase was to some extent top-down approach as well. So, but I would come back to this bottom-up approach. So, what are the stakeholders? These are not nation-states, as I understand in this case. So these are what they are, please name them. And second is, who would coordinate those stakeholders? Is some pan-European institution who would be involved in this? I mean, if the Latvian stakeholders are willing to participate in the process, what they should do in this regard? What they should, what is the way of participating and making their voices heard, not just on Latvian level, but also on European level, contributing to this debate of fundamental values within European Union?
Well, of course, the stakeholders are European citizens themselves. And I think that is really an important subject. I've recently published a book on citizens' rights and the right to be a citizen. That is a concept that is important within each of the states, member states of the European Union or states anywhere in the world. And we see, and we should be aware of this in these years as well, we can talk about Syria, we can talk about Ukraine, we can talk about the Netherlands. There are growing difficulties about understanding and accepting in a world that is full of tensions, that from the point of view of the state, of the public authority, of the guarantees under public law for every human being, we are equal. And there may be differences, and these differences can be important to persons with respect to their cultural identity, their sense of belonging to a nation, having their own traditions, maybe also their fate and role in history, or about their religion. Nevertheless, from the point of view of a polity that adheres to the rule of law and the principles of the human rights, the values expressed in Article 2 of the Treaty on European Union, we are all equal. And nevertheless, we need public institutions that safeguard our equality before the law, the trustworthiness of the procedures in any state structure, and that is something that should be organized by the state and by the European Union in the interest of their citizens. So when I was speaking about bottom-up procedure, I was not talking about something that should emerge as a sort of spontaneous revolution in the interest of the rule of law among our citizens. It is about an initiatives that the governments have to take and that the institutions of the European Union have to support. But they can mobilize the forces that are present within the societies of the member states of the European Union and the institutions that already existed. The question that the government of the Netherlands submitted to our Advisory Council on International Affairs is, do we need an additional initiative, an additional mechanism with respect to strengthening the rule of law in the member states of the European Union? And in our report, we first of all discussed why it is important to discuss the desirability of such an initiative. And there are two reasons. First of all, because it is important to strengthen the trust of our citizens in the legal systems, not only of their own member states, but also of the 27 other member states. And in the second place, we said that it is important for us to discuss such an initiative because it adds to the credibility of the European Union in their foreign relations. And then we said, do we need that we build something completely new, with new investigative bodies, with new institutions? And there we said, we have forces, ideas, and knowledge that is already there, and we should build upon these existing bodies of knowledge about the shortcomings and what to improve.
Okay, Minister, thank you. So I think we'll still come back to the stakeholders. I think it is important, and there are stakeholders sitting here as well, and I think that it's important to understand also the ways of how to participate. But already I am giving floor to Morten Kjærum, who is Director of the EU Agency for Fundamental Rights. But if I may, again, sort of my starting question would be, because Minister mentioned the second article of Treaty of European Union about the protection of human rights and fundamental values within the European Union. But I understand that fourth article of the Treaty of European Union actually is protection of constitutional specificities of the member states. So isn't there some kind of paradox and some kind of tension between those articles within the Treaty of European Union? And the question is, should the EU take more responsibility in this regard? Isn't it enough? And shouldn't be already well, it's enough with what we have and some respect for those constitutional specificities of the member states. What about the EU role? Should it be enhanced in fundamental value protection domain, please?
Thank you very much. Let me start by, first of all, thanking for the invitation and a very good initiative. I think it's a very rich discussion that has unfolded, and I really want to be concerned, with all due respect, of the letter from the four countries, which was extremely important in pushing the discussion ahead. But I would still also come back, as was said earlier, and give a lot of credit to Ernst for pushing it back in 2007, 2008, and really getting the discussion going on issues of rule of law, but also in that wider context, as he has just very well explained. I mean, we should not forget that we do have the Copenhagen criteria. Nobody, I think, actually mentioned the Copenhagen criteria. So, and of course, having, let's say, and that's where you look at the constitutional setup, the constitutional makeup of the potential candidate or the candidate countries. So we sort of say worked from the outset that countries which have entered, have become members of the Union, there the constitutional setup in terms of fundamental rights, rule of law, minority issues, all the issues mentioned in Article 2 is in place, and thereby we will probably not run into, let's say, that conflict that you're alluding to. Of course, what may happen is then that you suddenly start changing the constitution and you start eroding some of the institutional makeup, whether it's the court system or other independent bodies that you challenge, or other challenges of some of the core values. And this is, of course, the heart of the discussion where we are now on rule of law. How do we address such a situation? Because we have only foreseen in the whole make-up that things can only move forward. We haven't considered that things could certainly, or rule of law issues could start sliding backwards. And this is the outset. Let me just come back to that in a second, but let me also underline, because there's been this, sort of say, where are we on human rights in the Union? I would say that the way we have seen the Union going about implementing human rights the last, I would say, 10 years is amazing. I don't think we have any other structure in the world where we have such a, point one, recognition of the problems that we have, and also policies, strategies to address them, and finally institutions to actually deal with them. So when that is, and that is of course first and foremost, I would say, the Lisbon Treaty that entered into force in 2009 with the infringement procedure. I mean, we see nowhere, let's say, an institutional make-up addressing fundamental rights as the infringement procedures. It could be used more. It could be addressed in other cases than it has, but it's there, and it's definitely to be picked up on. It's also interesting to see in this light when people, European citizens, are being asked what do they expect from the European Union, then fundamental rights protection is always number one. That is really what people perceive, see as the, I would almost say, the raison d'etre for the Union. And going back historically, it's probably not that surprising. So, but coming back to then the challenges. What we now have is that we first saw an economic crisis coming in 2008 and very harsh austerity measures. And here the Commission came in, I think, very wisely at an early stage with the Justice Scoreboard. It has been criticized. It may not be as powerful, as strong as we would have wished, but it's there creating that link between the economic policies and justice, where we are only going down an avenue of austerity measures and the, so to say, didn't really recognize the full impact of that. There's still a lot to be done in that area. Now we're seeing the framework, the strategic framework on rule of law, which is a next step. And I would also mention in this regard the paper coming out, the annual report on corruption coming out of the Commission as well. So I think we have these three mechanisms now, which all together, in let's say in a first step approach, are recognizing and addressing some of these, the core values in Article 2. Let's go further. What we from the Fundamental Rights Agency very much would like to see is that we expanded, as I also hear from the other panelists, not only a narrow perception of rule of law, classical, you could say, legal approach to what is rule of law, but the wider, basically, Article 2 approach, and then have a much more coherent fundamental rights framework strategy for the years to come. That's what we really miss. And that's coming also back to what Ernst is saying on a bottom-up approach. How do we involve in a, you could say, a fundamental rights, an annual fundamental rights cyclus? This is language taken from the European Parliament in a report which I really like. I think it really touches on. We need, so to say, have a cyclus, an annual cyclus, where all the different actors, from the very local level, you could almost say the municipal level, but definitely to the equality bodies, the national human rights institution, the ombudsman, all those at the national level addressing human rights issues, which of course should then link up to my own institution, to the Commission, to the Gender Equality Institute, and other actors into then the Parliament, and definitely to the Council. Commission is already there with the initiatives that I just spoke about. But we need the Parliament, we need the Council much more integrated in an annual process, and as was rightly said, with the bottom-up, getting the data, getting a more coherent approach also from the national level. Finally, I would mention in this regard an institution which is often not drawn in, and that is the national parliaments. There's a big mistake if we sort of leave the national parliaments out of it. So one proposal that we're tabling is, why do we not create a collaboration between the human rights committees or the legal affairs committees, between all the national parliaments? It's something we're already discussing now with the Italian Parliament during the Italian presidency, to see whether they could actually host such a meeting, to see how to get these committees also to feed in. So I would actually subscribe very much to the line that, yes, it's fine with these, let's say, mechanisms as limited as they are, but we can do so much more by using the already existing mechanism. We can move the agendas way ahead if we get that stronger joined up human rights approach. So that would be, and I can say that we actually in a month's time will launch, and I have a draft here, 20 very specific proposals as building blocks for such a strategic fundamental rights framework.
Yeah, excellent, thanks. But I still would come back to this European Union's level, because again, bottom-up perspective is very important, approach is very important. At the same time, we speak about monitoring, we speak about enforcing most likely as well. So what the role of the European Commission, for instance, can play? Is it ad hoc approach? Is it changing of the existing treaties? Is it within the treaties? Is it enhanced cooperation within the European Union? So what's a mechanism coming from still top-down approach to some extent? Because at the very end, somebody will need to enforce it as well. So what would be your proposal, offer of the best, the most efficient mechanism in this regard, once we agree on some fundamental values also coming from bottom-up approach?
We already, as I said, we already have seen from the Commission, and that's going to be discussed. But I would not say that one approach, but I would just give you one example of what I think should be part of an annual cyclus. Let's agree on 10 key indicators of some key elements which are really challenging the core values. Let's just mention a few of them. Of course, independence of the judiciary, free media, addressing hate crime. These are just, let's say, 3. We could easily come up with 10 key indicators. And then you would request the Fundamental Rights Agency or collaboration between the Fundamental Rights Agency and Council of Europe to come up with an annual report addressing those key indicators for all the member states. And then you would have in the Council an annual discussion on what is, so to say, the temperature in Europe. Where are we moving? Are we moving forward? Are we moving backwards? What is happening year by year on a fixed set of indicators? I mean, that's just, let's say, one component that is being discussed. For the moment, we have, let's say, pilot project together with the Dutch government, the Finnish government, and the Irish government, where we're actually testing exactly this in the field of hate crime, in the field of access to justice, and in the field of, what was the last one, independence of judiciary. So each country have taken one, and then we are looking into what sort of data is already there, because there have been a lot of data is available, but there are definitely also some very big black holes, we have to say, and that's what we would then have to fill. But let's first look into what is there. If we have the indicators in place, how do we then populate the indicators with relevant data? Is the data there? So actually this spring, as an input to the discussion, we'll get from the Netherlands, Finland and Ireland targeted reports on some of these key issues.
Okay, thanks. Of course, it would be important also to make those indicators clear for those average citizens within the European Union, sort of not to make everything very complex and complicated to some extent as well. I think there is always this.
If I just can come in here, just
yes,
because
yes,
you have not,
shortly.
You didn't ask me about the citizen. I think this is highly relevant for citizens in all aspects. I mean, what we see in our reports, when we ask both minorities, and you mentioned also the violence against women survey, etc., this is all about asking European citizens what is the situation, what is threatening your life quality, and then trying to address it. And these data will definitely populate that sort of indicators.
Okay, thank you. With this we proceed to Viktors Makarovs, the Parliamentary Secretary of Ministry of Foreign Affairs. Viktors, do Latvian citizens need, let us say, the promotion of fundamental values, enforcing and supporting mechanisms within European Union and giving them more power also in hands of European Commission in this regard? What's Latvia's attitude?
Oh, thank you, Andris. I'll answer your question, but first of all, I would like to thank the organizers, all our wonderful partners, for the Ministry of Foreign Affairs. Thank you for organizing this seminar and also this great opportunity to discuss the best ways forward regarding promotion of fundamental values within the EU. Because to answer your question shortly, Andris, of course, each and every citizen of the EU, including each and every citizen and indeed resident of Latvia, does need strong protection mechanisms for rule of law and rights. The question is how to do it. It has been said here already, but I'll put it very shortly and bluntly, that the EU is a value-based union, and if rule of law fails in the EU, so does the union, and so does the EU in all the other areas. It concerns economy, it concerns the attractiveness of the EU, it concerns the soft power and the international standing of the EU. Because, to be honest, there are a lot of alternative offers available at the moment. There are authoritarian options that are being heavily promoted around the world. So the EU does not stand alone with a claim of having the right system. There are some alternative unions being created, or at least attempts to create alternative unions where rule of law is not really such an important issue. And to refer this Mars and Venus metaphor, I would slightly disagree, because if we believe that we are in Venus, where we respect, or want to respect, at least as much as possible, rule of law, I think that even those who live on Mars would rather live on Venus, because everyone wants to be protected. Also, the people who live outside the European Union. So part of the importance of this whole exercise that we're discussing here today is that we want the EU to lead the way. We want the EU to remain a model instead of just becoming obsolete and instead of being completely forgotten by everyone else. So the question is how to do it, and here I think the important thing to have in mind is a certain duality. It's true that rule of law and the values that the EU is based on, it's not an internal matter. We are supposed to be open, speaking to each other about these issues. It's a mutual obligation. And the new thing about the EU is that we're trying to create a common rule of law space across the borders of nation states, which are remaining. And here comes the other part of the dualism. Because if being a nation means basically it's a daily referendum, as Renan said. So being a nation based on rule of law also is a daily referendum. And the fight for rule of law is still being fought mainly within the nation states. Kaspars Dalīts has just mentioned one of those issues that we are probably going to discuss in Latvia. And this is something that we here in this country have to live through. We have to have an honest discussion. And no EU instrument is going to help us if we are not ourselves active and serious about this particular issue. So what the EU can do, and what the EU has done for Latvia, for example, during all these years, is to encourage, to provide an international framework and support for the states to do their part of the job on implementing the Copenhagen criteria and so on and so on. So I think it's very important for the EU to understand what its real role and real possibilities are, and to do it right, to implement these ideas correctly. Because if we create a mechanism that is not actually going to be used, because some countries believe it's too strong, some countries believe it's too vague, it's not going to work. So we need something that is carefully geared towards the actual situation and the actual state of the European Union at the moment. And there are a lot of things that, there are plenty of things that the EU is doing which are right, which are very good. There is a strategic framework for human rights and democracy that takes care of the external dimension of this issue. There is also, as we very well know, the legally binding fundamental rights charter, which, according to a recent EU Commission report, is getting more prominence. The awareness of the Charter is growing within the EU, which is good. It's being implemented more in practice, which are all the right steps. And there is, of course, still room for further improvements and more initiatives. And this requires a debate which Latvia is ready to contribute to. So we welcome the communication of the Commission on this subject, the one that we are actually discussing today. It's a good point of departure. I'm very interested in hearing more about what the four countries have to say on this issue. So it's a very good debate, and it's important that for us, it's very important that it's based on the existing EU legal framework, which has been noted here already, and that the Commission is determined to ensure the equality of all member states and avoid selective approach. And I think the key here would be to have transparent criteria that are applied and interpreted even-handedly.
Viktors, if I may, because I think we are running gradually out of time. So,
yeah, to conclude, basically, it's a good discussion to have. to continue what's important to pay attention to, we should avoid duplication. We should be very attentive when we discuss the modalities, what is going to trigger the situation, whether it's going to be an ad hoc mechanism or a generic mechanism and so on. This has to be discussed in detail, and most of all, we need a constructive atmosphere and trust among the states for this to work. So let's be open, but let's discuss it and do it right. Thank you.
Victor, thank you. And as you said, I think it's important to have a good discussion. I think we have a good discussion, but at the same time, the devil or devils are in the details. And
that's why we should discuss it.
That's why we should discuss, and so to bring to another level, more detailed level. But I would like sort of you would clarify, again, if I misunderstood it, but you said that basically the EU cannot help us with human rights, fundamental values, unless we do it ourselves. So it means that Latvia is quite, to put it mildly, reserved about providing new additional mechanisms to the European Commission, to the European Union. Basically, it must be solved within Latvian society. As you said, every day is a referendum. It is more or less about national, belonging to society, belonging to the statehood. It's national referendum. It's national fundamental values enforcement and building within a national perspective. So what's Latvia's position providing new mechanisms, enforcing EU role in all of this? But shortly, please.
Well, first of all, there is, I think, a great deal of willingness in Latvia to continue to improve the situation and the mechanisms of rule of law. Well, sky's the limit. So this willingness is there. So we are, of course, interested in a strengthened EU effort. Again, the issue is how do you implement it in the most effective way? And this is a matter of a very practical discussion. What specific mechanisms are going to be the best way to achieve that goal?
Okay, Victor, thanks. With this, we proceed to Stefanie Schmahl, professor at the University, Julius-Maximilians-University Würzburg, Germany. And after all this discussion, you are, to some extent, as not an official. Do you see that there will be the real feasible outcomes of all this good discussion what we have at the table? Can we speak about feasible discussions when there's bottom-up approaches, top-down approaches, nation-states, citizens involved? Do you see the feasible products, feasible outcomes coming?
Yeah, thank you very much, Your Excellencies, ladies and gentlemen. First of all, I also would like to thank the organizers for the invitation to this conference on a really important issue. I indeed would like to focus specifically on the added value of this mechanism, which the Commission proposed on 11th March 2014. As we already have heard, the fundamental values of Article 2 TEU form the constitutional profile of the European integration, and they do not only address the European Union and its institutions, but also the member states. This we can also read in Article 49, Treaty on European Union, which constitutes the legal basis for any accession, and this norm requires prospective members to correspond to those founding principles. But we also have Articles 2 and 7, Treaty on the European Union, which both give legal expression to the assumption that current member states have achieved and preserved the constitutional principles and fundamental values. This presumption is a matter of common interest. The fundamental values of Article 2 do not only legitimize EU decision-making, but also the implementation of EU legal acts at national level, which is essential for the proper functioning of the Union. In particular, the observance of the rule of law is an indispensable prerequisite for the protection of fundamental rights, and it plays a key role for the mutual recognition of decisions and acts of member states. Now, as long as the founding principles of the Union are observed in a general way, sporadic breaches of European Union law can be treated as mere exceptions to institutional normalcy. Isolated infringements occur in any legal order, and they do not, as such, undermine the fundamental values enshrined in Article 2. Rather, in well-functioning legal systems, such isolated infringements do induce institutional responses which serve the function of the rule of law. Lately, however, deviations have become known and prominent that rather than being isolated problems, they appear to be entrenched and widespread. Recent European Union reports point to serious insufficiencies on the functioning, on the fundamental rights protection, as we have already heard of this, and the rule of law in the administrative and judicial apparatus of several member states. Their legal orders are fragile in structure due to various incidents such as organized crimes, corruption, lack of institutional capacity, or judicial weakness. These problems can be qualified as systemic, and they do pose a threat to the founding principles of Article 2. If law infringements gain regularity and remain broadly unsanctioned, then normative expectations of Union citizens are frustrated, and the legal systems fail to exercise its core function to generate and fulfill reliable expectations. This is the reason why systemic deficiency in the rule of law has to be effectively remedied. Yet all European Union member states do rather well in global rankings regarding the rule of law and government effectiveness. Although there's considerable variation between them, they are in principle well designed to protect citizens against any threat to the rule of law, and none of them is considered as weak by international global standards. However, institutional capacity of an European Union member is not to be assessed with reference to global, but merely to European standards. And this is not only because of the character of the European Union as a community of law. It is rather because of the deep integration. Both the shared frame of Union law and the close territorial proximity of European Union member states increase the probability that dysfunction in one member state will have negative significance for others. The European arrest warrant, the Dublin regulation on asylum seekers, and other European Union legal systems are all based on reciprocal trust and cooperation, on mutual recognition and enforcement of decisions. Ineffectiveness of one member state may have detrimental effects to the system as a whole. It is therefore a pressing need to deliberate on how the mentioned endemic deficiencies in some of European Union members can be redressed. Neither the normal infringement procedures, nor the preliminary reference procedures, and nor the enforcement mechanisms set out in Article 7 Treaty on European Union appear well suited for reacting to systemic endemic problems. The instruments are far too case-specific and tackle, the first instruments, the normal infringement procedures, are far too case-specific, and they tackle only with infringements of provisions stemming out from European Union law. They are not applicable in situations of concern which fall outside the scope of the treaties.
Professor, I'm sorry, just 1 minute, please, because we're gradually running out of time, so please come to the conclusions.
And the enforcement mechanisms of Article 7 Treaty on European Union are not confined to areas covered by European Union law, but empower the Union to intervene also in areas where member states act autonomously. However, also these mechanisms are not properly tailored for the handling with systemic deficiencies, because they ask for a threat of particular gravity and duration. In addition, the enforcement mechanisms of Article 7 only lead to the suspension of member states' rights, and it is questionable whether the suspension of a member state's rights can be considered as an adequate solution to restore the rule of law and to redress situations that amount to systemic deficiencies but fall short of serious breaches. Instruments that may respond effectively to systemic problems need to be more timely and less invasive than the enforcement mechanisms set out in Article 7. What is required and might appear more promising than suspending membership rights is a monitoring mechanism that supports dialogue on the effectiveness of domestic judicial systems. And this is the reason why the European Union framework to strengthen the rule of law indeed does fill a gap. Thank you very much.
Thank you, Professor. Thank you. I'm still tempted to ask I know this little bit, it seems, a taboo question here to name or shame, and nobody wants to mention some countries, but still you mentioned on quite a number of occasions some countries, deficiencies, violation. Would you mention some examples? Just otherwise we speak so much abstractly in many regards, and would you as a professor, not being a formal representative, can mention some examples, what has happened?
Let me say, well, I can name one thing, which is very known. The European Union has a so-called special cooperation and verification mechanism, which the European Union established in the Act of Accession of 2007 in order to help Bulgarian and Romanian institutions address structural shortcomings and monitor their progress towards meeting European Union standards. This mechanism is country-specific, and it is also based on a dialogue, but has quite significant monitoring power and gives quite a significant monitoring powers to the European Union institutions. The drawback of this mechanism, which functions quite well, is, however, that it applies exclusively to Romania and Bulgaria. It therefore puts the equality of member states under heavy strain. And the new framework, by contrast, seeks to ensure that all member states are treated equally. And we also know that we have had some problems since the financial crisis with several member states as well. But the framework will apply in the same way to all European Union members and will operate on the basis on the same benchmarks as to what is a systemic threat to the rule of law. So I don't want to go into details for naming and blaming or shaming.
Blame or shame,
You know?
just name.
But I mean, this is not the purpose of your new framework neither. Maybe we have some member states which have more problems with respect to the rule of law at the moment, but you never know what will happen during the future. And the framework has not the idea to pick out concrete member states, because it just wants to enlarge the special cooperation and verification mechanism, which was a country-specific mechanism only concerning for Bulgaria and Romania. And
Okay, yeah, at least some examples, very good, thank you. So and we still have 20 minutes, and I want finally also to give the floor to audience. Please, the floor is open, and please raise your hands and introduce yourself. And here and over there, yes, yeah, please.
My name is Valdis Liepinch, I'm a member of Parliament. And I was listening very carefully to everything that you said. I didn't actually hear a discussion. I heard five presentations with a few questions from the moderator. My question is, what would you say are the fundamental issues that need to be tackled across the European Union to fix the problems that you have identified? There have to be some sort of common problems, some common deficiencies. The speaker from Finland noted 3 or 4 or 5 examples, all of which refer to intolerance in one way or another. So is intolerance one of those issues that we need to be tackling across the Union? And what are the others? Thank you.
Okay, thank you. Yep, please, Baiba.
Hi, hello. Is it on? I'm Baiba Broka. I'm Director General at the Foreign Ministry for Security Policy and International Organizations. And my question is for our Finnish colleague here and my dear friend Ernst Hirsch Ballin. I was quite excited to hear that this mechanism might address the concern about raising nationalism and extremism in EU member states. So I would be really interested to hear how exactly do you see that, and whether that would address, for example, the growing popularity of Geert Wilders or True Finns in your respective countries, and how exactly that would work. Thank you.
Okay, thank you. Yes, there, Ambassador.
I would like to help you in provoking discussion a bit. I'm Danish ambassador. Because it seemed as if authoritarian threats, Ukraine, or one could go further back and say 9/11, was only helpful to promoting fundamental rights. But I could go back, as I said, to September 11, and we could talk about fights against terrorism and Snowden and other things. I will not do that. I will talk about Ukraine and your country, because suddenly 2 weeks ago I had several Danish journalists in the phone about something happening in Latvia. It doesn't happen so often, but there was a Russian TV station which was shut down, and they wanted to hear what that was for a strange thing, that in a democratic context you were shutting down TV stations for telling about what was happening in the world. And I had suddenly to go in and tell about the situation in Latvia and the Russian minority and the different information spaces and things like that. I would like to have Viktor's comment and one of the other ones.
Thank you, Per, for contributing to the, trying to make it more provocative for the panel. Yes, please.
I'm Morten with the Embassies of Denmark, and I will not do any naming and shaming, but instead I would like to do some naming and praising. And that refers to what Mr. Harm's intervention in the beginning. You were asked to name a couple of problems in other member states, which you politely declined to do. But what you did do, you named a couple of issues that were an issue in your own country, in Finland. And with that, I think you showed some refreshing openness, which I think is very important, and especially as an advisor of the Finnish government, I think you are very, very advanced in that, I would say, and I would like to praise you for that.
Thank you.
And I think this openness is one of the preconditions of this rule of law mechanism that we are discussing today. And I'm actually wondering if in all member states we will see the same openness as in Finland. So maybe that's a question I would like to pose to the other panelists. Do you see there is enough openness in your own country to make this mechanism work? Thank you.
Okay, thank you. So I think we come back to the panelists, and there are quite concrete questions about the RTR Russia, or the Russian channel, being closed down in Latvia, and there is about True Finns in Finland, and there is some spectrum what other panelists also can address. Please, but let's start with the Finnish representative.
Thank you. Very good question. The answer is no. I think that the problem in Europe in general, which results in human rights violations, is growing nationalism and extremism and disrespect for minority rights. But of course the mechanism can only per se look at the fundamental values and the rights which are, for example, in Article 2. It doesn't forbid nationalism, it doesn't forbid extremism, but I was just saying that I'm worried about the general atmosphere and the developments which very much are a cause of nationalism and extremism. Then they lead to discrimination in individual cases where the individual's human rights are not respected.
Okay, Viktors.
Well, as far as I know, we are talking about RTR, which has been suspended, not entirely thrown out forever, until the legal situation is clarified. And I understand why this is such, why this is being discussed, because of course freedom of speech is a fundamental value. Freedom of access to information is important. There are two sides to this. One is that freedom of speech is not absolute. Certain kinds of speech are not protected. And as far as I understand, the legal argument of the authority that has acted in this situation is that this is not about freedom of speech. This is about limiting hate speech on the Latvian soil, which is probably a legitimate argument to make. There are certain mechanisms and certain factors to be evaluated, like the proportionality. Is the response commensurate with the actual threat? Are there other means of achieving this? And so on and so on. So this is the legal discussion. I'm really thrilled to know what becomes of it. There is another aspect here, of course. We should combat hate speech, and a country has a right to defend itself against aggressive and hostile activities such as the propaganda coming from the Russian Federation in this particular case. We should also evaluate whether prohibitions and just cutting off the cable are the right way to achieve the goal, because the goal is to maintain calm in the society, to avoid conflicts. And I think the main instrument to achieve that is not cutting out a specific Russian channel, but rather invest more into having public media in Russian broadcasting as media outlets should do, instead of just having 3 or 4 or 5 pipelines for undiluted propaganda, which is the case at the moment.
Mm-hmm. Okay. Mr. Kjærum. Thank you. Let me come back to the naming and shaming. If I have time, I can mention, I don't mind mentioning all 28 member states. No, but one of the beautiful things in my work is that I sincerely can mention all 28 member states as number one in one or the other area, at least belonging to a group. It all depends what is the question you ask. What is the particular issue? If you look at, for example, delayed justice, well, then you would have problems in Western European countries, because the Eastern and Central European countries are much further ahead, many of them, in using electronic means, updating their system. If you look at intolerance, in particular against sexual minorities, you see a religious dividing line between countries. If you look at racism, hate crime, you look at those countries which have had most recently immigration flows, or where you have had very homogeneous countries, etc., 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 etc. And so you can read our reports. We mention the countries. We don't shy away from mentioning, because people actually do live locally, and they live, so to say, in member states. So therefore, of course, we do mention them as well. Are they open or are they not? I think that's a very good question, and there's definitely, I would immediately echo what was said, that Finland is exceptionally open, also when it comes to reacting, for example, to our reports, where we see other, also Nordic countries, which are totally the other way around, basically trying to make the facts go away, denying it, trying to address the methodology, or is it now the right questions that were asked? And I mean, it's really, but there are a number of other countries also doing that. So yes, there is something to be worked on in relation to openness. Some are definitely more open than others. Are there some common issues, as you mentioned? I would you pointed to one yourself, intolerance. And I was thinking that was maybe a bit easy, just echoing what you said yourself. So I had to come up with another one. One area that we see also cutting across is understanding independence and respecting independence, whether it's judges in court system, ombuds institution, data protection institution. We just released a report on data protection institution authorities across the the member states, it's appalling. I mean, they should be independent, and they are not very independent, most of them, and they're poorly funded, weak mandates, etc. The same with the equality bodies and national human rights institutions. We still have a long way to go, and I would say across the board, on understanding what is a truly independent institution all about. And then finally on the, which was raised on intolerance, I mean, could this mechanism, a new mechanism, actually address the true Finns or the Danish People's Party or Marine Le Pen or something like that? Definitely one of the elements that, and here I will also mention two countries again now. We just released right before Christmas a report on extremism and intolerance in Hungary and Greece. Looking into, not in particular to highlight these countries, but see what are the lessons learned, because they have had some, and have some very extreme parties actually in the parliament. And how did they react to it? They reacted differently. Also to the fact that it seems like these groups are also linked to paramilitaristic groups. So I mean, we are really in the serious end of extremism. And of course, one point here that I could easily see a mechanism dealing with is to what extent are these issues raised by the prosecution, the police? How is it being investigated, or is it just being tolerated? Coming back to, for example, hate crime, what sort of mechanisms are in place in order to report hate crime to police? And if it's reported, what is then the situation regarding the prosecutors? Do they actually address it? If that's systematically, and here I'm talking about systematically, not addressed, I would say that would be an issue that could be lifted, because here again we are into something totally in the essence of the democratic society. I see you disagree, but I would like to...
Okay, yeah, thanks. Hirsch Ballin, please.
Well, I think I need to clarify 3 points listening to the questions. First of all, bottom-up or top-down. That was an issue that was raised in several of your questions as our chair, and that is related, I think, to your repeated question to name some serious problems that should be our reason to embark upon an additional initiative. Well, I think when we have serious shortcomings in the functioning with respect to the rule of law, or maybe preferably the German-Dutch expression of the Rechtsstaat, which is, well, the translation in Article 2 of the Treaty on European Union of Rechtsstaat is rule of law, but Rechtsstaat has also something to say about the way in which the administration and the judicial authorities are doing their work, so the concepts are not perfectly identical, but here I use the English expression of rule of law. We should not limit ourselves to dealing with those serious problems which might be a reason for the implication of an infringement procedure or Article 7 of the Treaty on European Union. That is, of course, important. Of course it is important to address such serious problems, and therefore I think the initiative of the European Commission is really useful to create a mechanism that prepares or prevents the application of Article 7. But the proposal that we have submitted to the Dutch government, and which might be, if the Dutch government would agree with our recommendation, part of the Dutch or the joint initiative of the 4 member states that already have written the letter that you mentioned before, is to complement such an enhanced enforcement mechanism for the Commission with something that builds upon the experiences on the ground. Of course, that is not only a process that goes from bottom up. It goes, in return, it goes top down, because there have to be adopted recommendations by the European Council of, by the Council of Ministers of the European Union, and they have to communicate it to the European Council, and they have to monitor the follow-up of these recommendations and so on. but it can deal with those daily problems that a European citizen might encounter in dealing with the authorities of their own or other member states. That is really about the quality of the rule of law, of the Rechtsstaat, throughout the member states of the European Union. So it's not a question of either something that is weak and bottom-up, and something that is a strengthened enforcement mechanism from the side of the European Commission. It's a combination of the two, and that is, in our view, really important. Now, the second point that I'd like to discuss, listening to the questions...
Just to try to be short, because we would like to give it a last round of questions.
I will try to be short, but to be clear as well, thank you. Is about citizenship. And what I said before, and what was raised in some of the questions as well, is about the nature of the citizenship in our member states and in the European Union. And there was a question about the television channel in Latvia. I don't have a vision about these problems. I don't know enough about that. But what I know for sure, that it is important for all of the member states to have an inclusive citizenship that goes that will be recognized by people from different backgrounds, culture, ethnicity, religion, and so on. So citizenship, by its nature, should be inclusive. And that is a problem with which several member states, if not all, have to deal, and which is really important in times when xenophobic and nationalistic and Europhobic parties and authors and politicians stand up against not only the European Union, but also against the very values of the European Union, which includes this inclusive citizenship.
But Minister, but if I may immediately to follow up, so it means that you would say that those countries which have not inclusive citizenship, that actually should make it more inclusive.
Well, I didn't say that countries have no inclusive citizenship, but it's something that requires our continuous attention to pay, to do justice to every citizen and to maintain an inclusive citizenship. And the reason, and that's my third and last point, that we have these positions that challenge the very nature of the European Union and our cooperation and these values of citizenship is distrust. And you can't respond to distrust with additional distrust. The only thing you can do is to work for building up strengthened trust. And how do we build trust? With equal justice and authorities and judicial authorities who pay continuously attention to the interest of all their citizens. That is how we build trust, and that is the core issue in our report.
Mm-hmm. Okay, yeah. So let's have Professor, as the last round, I will give you the first floor. So let's have a last round of questions, and since we are running out of time, please.
Just to add up to some of the things that were raised with regard to right-wing nationalism and how it is affecting. One of the things is, I mean, with a little bit of focus on the UK, is that it's not just right-wing nationalists that are taking up this cause. You know, main ruling parties, I mean, including the Conservative Party in the UK, for example, has taken up this stand of a bit of, I mean, Europhobia. I mean, Conservative Party has been slightly distant, but this time, what I'm trying to say is not just in the UK, but in other parts of Europe as well, when there is a racing notion, other political parties, for their own political gains within their nation states which form the EU, do take up this cause. So how do you then take or promote fundamental values in such situations, which is slightly harder for, for the FRA to publish its report and convince people? So, yeah.
Okay, thanks. Yes. Some other questions, please. Yep.
One question, very brief question to probably all of you. The rule of law.
Please introduce yourself.
My name is Christoph Schäbe. I'm working at the University of Latvia for the German Academic Exchange. For the German Academic Exchange. The rule of law is not for free, and also in the sense of Rechtsstaat. You have to pay for the administration. And one of the points, which has also been addressed by the communication of the European Commission, is the functioning of the police, for instance.
Yes.
So the question is, after the austerity measures, some countries, especially, or among others also Latvia, have been praised for the good measures which have been taken. On the other hand, if you cut the salaries of police officers, for instance, this is not precisely what has to be aimed with this communication, for instance. So the question would be how to finance all those activities which are to follow. Thank you.
Okay, thanks. Yes, there was some question also as well. Yeah. Yeah.
My name is Ulrich, and I'm also from the University of Latvia. I would like to ask more about, there was a very good idea to bring more down communication and exchange with national parliaments. And looking at my experience working with Latvian Parliament, and particularly on the issues related to fundamental values, which are very well introduced in other European states, the parliamentarians are quite often very reluctant to promote and to deal with issues, and particularly I have experience in working with reproductive rights and children's rights. And I would like simply to, I see this is a very important point, but I would like to have your ideas how you see the way to proceed with more, and I would not say influencing national parliament, but with more encouraging national parliament to work on fundamental values from a perspective of member states.
Yeah. Okay, thanks. Please.
Hello, my name is Inga Reina. I work at the Foreign Ministry. I think the key questions, what maybe you could elaborate on, is what to monitor and by whom. And well, you have mentioned that extreme nationalism is not a good idea, at least not in Finland. Well, maybe the national human rights institutions, which is extremely exciting, but then the question is against what background and where is the competence of the European Union on that? Well, maybe against the Paris principles, but I think there we would have a strong divergence of views on how far these principles would be applicable within the remit of EU law. But the Treaty of the European Union is relying on two basic pillars. One you have mentioned are the common democratic values, and the other one are constitutional traditions. And I think there you would need to reconcile, and maybe you could mention some more examples. You have mentioned, well, national human rights institutions, extremely exciting, police and intolerance. How would you view this being monitored? Because if we take this example, you have a disagreement of, for example, one of the basic disagreements on the hate crime is whether it is a separate crime or it is a usual crime with aggravating circumstance. Do you think the Commission has the capacity and the knowledge to assess that specific aspect? And if you take another additional element, for example, the recent ECJ judgment on the Data Retention Directive, that brings us down to the quality of EU law as such, and the Commission being one of the major and the main legislator of EU acts, where it obviously fails on many instances to comply with the basic requirement of the quality of the law. And if that institution is to monitor then the quality of the act of member states, well, how would you see that being put onto the agenda? Thank you.
Thank you. There we go. Because this is the last question, unless there is somebody else. Yeah, please.
Good afternoon. My name is Shirin Gurdova. I have a question regarding the Turkey's accession to the European Union. How do you think that it would be possible to promote, uphold these fundamental values in such a country like Turkey with its potential accession to the European Union, considering its larger population, it's predominantly Muslim population, which values might be slightly, maybe not slightly, but quite different from those which are here in the European Union. Yeah, thank you.
Okay, thank you. I guess this was a last question. Yes, so 1 minute each. And we do it in a reverse order. Please, Professor, the floor is yours, and please select, of course, those questions or those points you would like to address, because I guess we'll not be able to discuss everything now in the last 5 minutes. So please.
I try to be brief. Thank you. First of all, I would like to say that we should better differentiate in between fundamental rights protection on the one hand and the general atmosphere of tolerance or intolerance of the population on the other. They are closed, but they are not identical. Because if you have the fundamental rights protection, it can happen that you have two individuals which are confronting each other. One individual relying on the freedom of speech, and the other on its religious feelings, for example. And this is the moment where the rule of law is very necessary. The rule of law guarantees access to court, an independent and impartial judiciary, and which is competent to decide on cases which have confronting fundamental rights in between two different individuals. And then it is, and then this is the idea of the mechanism of the European Commission, which is a state-addressed mechanism. The mechanism has not the purpose to introduce a general feeling of tolerance into all societies. This would be very nice, but this is, I think, impossible for a state-addressed mechanism. The mechanism has the idea to better protect the rule of law, that every judiciary really works according to agreed rules, and if the judiciary doesn't, and the judicial apparatus and the administrative apparatus does not work well, then the trust of all citizens is vain. And this, I think, I want to highlight for the mechanism proposed by the European Commission.
I think that we can go on. Excellent that I think you provided on this mechanism. So, Viktors, please.
I'd like to comment on 2 points. First, I think the easy one is about the cost of rule of law. Unless you have oil, diamonds, gold, or such, the only way you create wealth is through having a stable business environment, which absolutely requires rule of law. So rule of law is expensive, but rule of lawlessness is even more expensive for a society that wants to be modern and developed. That's the first comment. The second, regarding right-wing nationalism and so on, just one remark to complement what already has been said. I think we often think of the problem as this broad mainland of political mainstream somehow becoming smaller because of the floods of intolerance and right-wing extremism and so on that's somehow encroaching on us. The problem often is that it's not so much about that, but about the fact that the mainland has become spongy and there is no firm value background that the politicians are ready to protect. So I think a huge part of the solution is for the mainstream political parties in the European Union to take up issue with those extremist forces and the populist forces that exploit the opportunities because of the economic situation and so on and so on. And this is something that has been lacking in I'd say many countries. I would specifically mention my own country, where I would wish for the mainstream politicians to simply have a voice, have their voice heard when something extreme is being said. And this is a problem that everyone should work on. It's not just about prohibitions.
Viktors, but you are a mainstream politician.
Yes, and I try to do my small bit and add my 2 cents to the debate. Unfortunately, that's not enough.
Excellent, yes. Mr. Kjærum.
Thank you. Quickly, one for the first one, how to convince the population about fundamental rights these days. For us, it's very much about, for example, selecting the topics. There have been a tendency, and there is still a tendency that, and also in this room, I would almost say, that each time we talk about fundamental rights issues, we talk about minorities, ethnic minorities, sexual minorities, and it creates this sense in majority population, what's in it for me? Is it only about this or that minority? So we are very conscious about having issues like access to justice, like right to privacy, etc., etc., etc. So we actually have quite, let's say, issues appealing to everybody. So everybody sort of get a sense that fundamental rights is not only for all the others. Rule of law, I would just echo what was said, that we cannot afford not to have it. But again, you could also look into, for example, as I mentioned before, some of the Eastern and Central European countries have been extremely innovative in using new technologies in actually saving resources without challenging the legal safeguards. So there are ways. Actually, some of the reforms throughout history, I think the interesting reforms we actually see in times of austerity. On national parliaments, I would just say we do not have a choice. I know it's difficult to engage national parliaments, but it would be really a very big mistake if we do not try to engage them much more so they get an understanding, stronger understanding of the European dimension. Look at what happens to national parliamentarians when they have been member of the European Parliament for a period. Their perspective changes quite dramatically. I can give you a lot of examples of that. Finally, on the police and the hate crime. It was hate crime I talked about. If you, for example, I'm not saying it happens, but if you saw, let's say, a systematic neglect of attacks on Roma, on migrant, on religious minorities, and there was, so to say, no reaction from the side of the law enforcement, there I would say this is a key a rule of law issue, and there would be a competence.
Thank you. Minister?
We lawyers have a lot of knowledge about how to deal with conflicts, but I think we need to have more knowledge about how to build and strengthen trust. Intolerance, it was mentioned before, is the superficial phenomenon of distrust. And what is important, in our view, about this initiative is not to have a new mechanism for dealing with conflicts, but to have additional procedures for strengthening trust. And trust among citizens and between citizens and their institutions, the institutions of their states, of the institutions of the European Union, is a question of reliability, of reciprocity in due respect for every human being. And that is something that manifests itself not only in the way in which the authorities deal with the big conflicts in a society, but it is about the daily work of dealing with the interests of the citizens. That is why some of our examples in this report are not about huge conflicts, about people who are tortured or something like that, but about people who experience that the judicial authorities don't take notice of their complaints in due course, or about authorities who deal with the application from a European citizen from a different country with undue delay. It's about these daily experiences of the authorities living up to the standards of the rule of law, of the Rechtsstaat, that our initiative is about. And that is, I come back to the question that was raised by from the side of your Ministry of Foreign Affairs about constitutional traditions and constitutional values. Well, in the very basis of the European Union, and that will apply also to the possible accession of new member states of the European Union, is that we are different in many respects, have different histories and languages and traditions and constitutional identities, but that we share also very important things. So the case law of the Court of Justice of the European Union and Article 2 of the Treaty on European Union and a lot of other fundamental explications about the nature of the European Union are about our shared constitutional values. And we should strengthen these values in the daily experience of our citizens, not only with respect to the big issues that result in indignation, but also the daily experience of citizens who have to deal with the authorities in their own and in other member states.
Okay, thank you, Minister. Yes.
Thank you, Chair. I'll try to be brief. I'll comment on two things that actually were already addressed by also the other speakers. First, I think Morten was of course very right when saying that if you have systematic neglect of addressing people who from a certain ethnic background or so are filing cases with the police and nothing is being done, you have a systemic problem and you have a human rights violation. And also in my own country, Finland, I know that it's very easy to survey this. You can survey, or then you can go and look into the cases. And this has been done. And after it has been done, the police have actually filed cases as hate crime much, much more after we have raised this issue and after surveys have been done. Then I want to end on a positive note and continue where Viktor ended. I believe, I mean, nationalism and extremism, they are the minorities still. The tolerant people, the open-minded, are the clear majority in all member states, and this is positive and something we should cherish. But at the same time, of course, mainstream politicians and political parties have failed in not early enough addressing nationalism and extremism and going out and saying stop. One very positive example from my neighboring country, Sweden, was when the Swedish Democrats with a neo-Nazi background came into the parliament. I think they got 6% of the votes. You had huge crowds going out to the streets and saying, we are 94, you are only 6.
Thank you. And Viktors agreed to be very hospitable and reply the question on Turkey.
Yes, but also a very short answer. I think there is no a big candidate country is not an issue. A country that is not Christian by majority is not an issue. The issue is the compliance with the very well-known criteria, and I think in the case of Turkey, the state of play reflects that there is a readiness to negotiate on the accession, but again, the accession depends on Turkey being compliant with all the criteria that are well known. And I would say that the outcome of this process lies in the future, and it's I would say it's open. Thank you.
Okay, thank you. I have a very short rounding up remark, I guess, and I would use the phrase what Viktor said, that it has been a good discussion, and we need to continue a good discussion. Of course, it is important for also what you, Professor, started, but already some echoes were around the panel, that the good discussion on the values. It's important for the increasing tolerance, increasing understanding, increasing reciprocity within the European Union, and making the community of values, at least that we also think about it in all member countries. Of course, when we come to the details, we found the devil there, because it's not easy, because at the same time we realize also around the table discussing the issues and also having the questions from the audience that fundamental values, rule of law, actually it's quite a broadish subject. Starting from constitutional things to protection of personal data, to inclusion of minorities, ethnic and not only, etc., etc. So that's why, of course, for such a broad concept, it's quite challenging to find a concrete procedures, concrete mechanisms, concrete approaches, and sort of to coordinate all of this in a way which satisfies everybody, and not to just to stay on the level of what was mentioned in the beginning. It's just the lowest common denominators that we need to sort of go above it. So that's why I think it is a good discussions to start with, and we can name and shame all 28 countries, so it also means that we have to look domestically at our own challenges, but at the same time not forget that we are still community of those 28 countries, and we still try to speak sometimes with a common voice and common vision what our values are. So with this, thank you very much to the panelists. Thank you to the co-organizers. Once more, thank you to the Riga Graduate School of Law for hosting us and having again a good discussion. So already it's real on a regular permanent basis. It's a pleasure to cooperate with Riga Graduate School of Law. And thanks for the audience coming and showing interest and putting the questions. I think it means that all those questions, despite its broadishness, is still they're still very relevant. Thank you, and also to the panelists and co-organizers. And please join me in the last round of applause. And reception is downstairs.